Good afternoon, everybody. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Absenteeism and Abuse of Annual and Medical Leave. My name is Carolyn Ng. I'm an associate with Ma Wing Kwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises 32 lawyers and a support team of 34. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its today working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our offices since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking with clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. Details of that will be given at the end of this talk. Our speakers for today are John Chan and Jasmine Lee. Allow me to introduce John. He is a partner with our Dispute Resolution and Employment and Industrial Relations Department. He is also actively involved in the Bar Council Sports Committee and practices in a variety of areas, including unfair and constructive dismissal disputes, strata management disputes, and contractual disputes. Next, we will have Jasmine. She is an associate in our Dispute Resolution, Individuals and Families Department as an Employment and Industrial Relations Department. Her practice areas include employment and industrial relations, corporate litigation, adoption, immigration, and citizenship. We will also be having a Q&A session at the end of the talk. Please post any questions that you have into the Q&A chat box at the bottom of your screen. The points today are the employment law on absenteeism, the requirement for annual leave approval, employees' abuse of medical leave, and practical tips for employers. I will now pass the time over to Jasmine.
Thank you very much, Carolyn. So, good afternoon, everyone. My name is Jasmine. I'll be your first speaker of the day, and I'll be taking the first two talk points. Before we start, I just want to apologize. It may be a little loud because where I am right now, it's raining very heavily. So, apologies if you can hear that in the background. And just getting right to it, I just want to start off very briefly to talk about the unfair dismissal claims and the processes, how you can go about it. So, under Section 20, this is what defines a workman and basically defines who can bring about a claim for unfair dismissal. So this is where you find whether or not you're an employee of a company. And there's also cases to say that in order to dismiss an employee of your company, it can only be done if there is just cause and excuse. So you cannot simply decide to dismiss your employees because you don't like him. There must be significant evidence of his misconduct, like you're going to accuse him of such. And as for the processes itself, if you have been dismissed by your employer, you have 60 days to go to the Industrial Relations Department to file your claim. And the timelines are very strict on this. The courts are very strict. And even if you are just 1 day late, your claim would not be entertained. So just take note of that should you ever wish to file a claim. Industrial Relations Department. And these are the processes that you go through. So once you file your claim at the Industrial Relations Department, then a officer will come and assist you. They will call a company representative to come and have a reconciliation meeting. So this is the second portion here where it says settlement negotiation. And usually there will be about 2 reconciliation meetings. If you settle there, then that's great. But if nothing comes of that, then the Industrial Relations Department will refer the case to the industrial court itself. And that is usually where start to hire lawyers and they get involved, and the industrial court will determine the outcome of your case. And this is what happens at the industrial court itself. So usually it takes about 6 to 9 months, and parties will just have to file their pleadings. And then if necessary, you proceed to trial, whereby you file your written submissions after, where parties will be cross-examined and things like that. And then you'll be given a decision. So for the industrial court, it is usually much faster than regular civil courts. As for an award, it is by law that any employee that files for a representation of unfair dismissal, you have to ask for reinstatement. But if the courts find that reinstatement is not fit and proper for your case, then they just give you compensation. And this is how you calculate the compensation. The burden of proof, like I mentioned earlier, if the company is going to fire an employee and accuse them of any sort of misconduct, then the company bears the burden of proof to show that the employee is in fact guilty of what he's being accused of. Common cases, unfair dismissal are of course always misconduct, and there's an array of things that fall under the big umbrella that is misconduct, and this will include sexual harassment in the workplace, any criminal offences, breach of confidentiality, conflict of interest, insubordination, and of course the topic of the day, absenteeism especially. Poor performance will also fall within this umbrella. Redundancy, retrenchment, forced resignation, non-renewal contract, and constructive dismissal. So all of these are fair grounds for anybody to come and bring an unfair dismissal claim against their former employer. Now, getting into the topic of today, the employment law on absenteeism. So to define absenteeism, luckily for us, it is defined by statute under Section 15 sub 2 of the Employment Act, and it's quite self-explanatory. So if an employee has been absent from work for more than 2 days in a row without obtaining approval from his employer, then he is considered to have just committed a serious misconduct. Sometimes we'll get into this later, but it may be difficult for you to inform your boss beforehand, whatever the circumstances may be. So long as you have a reasonable excuse, then that should be fine. But if you don't have one, then that is a serious misconduct. So for absenteeism, it is a serious misconduct. We will again get into this a little bit later, and you can be fired, and an employer can terminate your contract of service without any notice because it's considered a serious breach. And for those people that are not considered, these days after the amendment to the Employment Act, most people will be considered employees. But in the unlikely event that you're not, then you will just follow the terms of your contract through normal contract law, whatever is stated. So the general principles is absenteeism a serious misconduct. Based on the case law, the courts have consistently decided that being absent without leave from your employer is a very serious misconduct, because it will significantly disrupt any company operations and affect productivity. So getting into the first case, this is Crown Plaza, Riverside, Kuching, which is a hotel against Muhammad Zulkarnain. So the claimant here was a steward of a hotel, and he was specifically directed to serve at a function that was being held at the hotel. So prior to this function, he did in fact ask to apply for leave, but was told that he couldn't due to the function. And it was based on the claimant's own understanding that he was to take 6 days straight of leave in replacement of him not being able to go on a public holiday due to the function. This was obviously not the case. And as a result of this, he did not turn up to work for 3 days in a row and made no attempts to inform any of his superiors or his co-workers. So when the function came around, they could not contact him, and they even went to his house later on to seek an explanation. And he was, of course, later dismissed, and he claimed that he, of course, denied all the claims. So he said even if he did do such a thing, the punishment did not fit the crime and he should not have been fired. So the court clearly disagreed with him, and the court held that mere absence from work for 2 or more days in a row does not immediately constitute a breach under the Employment Act or is a disciplinary offense. The absence from work must be without reasonable excuse. And if there is a reasonable excuse, then it is your duty as an employee to inform your employer. It's only common sense. And as for the first point where it says just being absent is not enough to constitute a disciplinary offense, what I mean by that is you have to look at the picture as a whole, considering all the circumstances. So like I mentioned earlier, there may be circumstances where you have to depart from work, and then whatever the case may be, you are not able to inform anyone. Then when you come back, you have to explain yourself, and if your boss accepts your excuse, then you'll be fine. And in furtherance of that, the court also held that the claimant here, the hotel steward, had been absent during the relevant dates where he was specifically instructed to attend the function and work at the function. And he failed to comply with basic obligation of an employee whose principal duty is to be present at his employer's workplace in order to render the services that are expected of him. So the court found the claimant's dismissal was with just cause and excuse. Next case for Pan Global Textiles. So the claimant here was a general manager of a textile company, and he was suspended pending investigation to several allegations of misconduct, one of which is, of course, him missing work deliberately. So they conducted a domestic inquiry, and at the conclusion of it, the claimant was found to be guilty. But instead of dismissing him, the claimant was just demoted to a different rank and told to report for work on a different day. So when this day came around, out of protest, the claimant decided not to show up to work for 35 days straight. And of course, as you could imagine, he was terminated. So with all the appeals that had gone on, it went all the way up to the federal court. And the federal court had agreed with the company in their dismissal of the claimant in this case, because it is proper cause for an employee to obey orders when given and to protest its illegality in separate proceedings. What that means is if he had done this out of objection to his demotion, so the proper avenue for that was to go and fight his demotion in the Industrial Relations Department, rather than taking matters into his own hands and then deciding not to show up to work for more than a month. So no employee can claim as a matter of right a leave of absence without permission and where there may be any permission for the same. Remaining absent without permission is a gross violation of discipline, and continued absence from work without permission will constitute misconduct, justifying the discharge of a workman from service. And the next case is Pulai Mewa against Leong Fuk Heng. The claimant here was employed as a supervisor of a company, and his main job was to supervise company workers and production of the company. So this case is slightly unique in its own way, because when it comes to a company deciding whether or not a worker being absent warrants dismissal, they say you have to look at the whole circumstances of the case. So here, we are looking at the nature of the employee's job. So the claimant here, the nature of his job, he was required to handle problems where if fights were to break out between foreign workers, he would have to bring them to the hospital. And sometimes he was also asked to entertain some foreign businessmen and take them out. So this would entail him working at very odd hours of the night, not within the normal range of office hours. And he had absented himself from work for more than a month without valid reason as well. And the company alleged that his work performance had been badly affected, and of course he was dismissed, and they did not offer him a show cause letter. So in this case, the company claimed that they had warned this claimant multiple times. They claimed they had verbally warned him 60 times. And the claimant says that no charges of misconduct formally were ever formed and sent to the claimant. They never explained to him that he had done anything wrong. He was not given the opportunity to explain his case because there was no domestic inquiry here. And there was a warning letter that was sent by the company, but the claimant had refused to sign it. So he denies ever even seeing this warning letter. And despite being repeatedly absent, the company had taken no action to terminate him, implying that the company had allowed his behavior to continue this way. So the courts had dismissed the claimant's claim. They did not agree with him. And the courts found that being absent for more than a month without any valid reason for his own benefit had deeply affected the smooth running of the company. And a warning letter must be issued to an employee that commits a misconduct. But specifically in this case, based on the evidence that was adduced, it was very clear that the claimant was not the type of person or employee that would sign anything that is given by his employer. And there was also proof that he had acknowledged the said 60-something verbal warnings that were given to him. And in furtherance of that, courts also found that the claimant should have been more aware as to why he was terminated, because he claims that when he was terminated, he wasn't given a reason. But it should have been clear to him now that if you don't show up to your work for more than a month, clearly you cannot perform your job functions properly. And he was also a supervisor, so it really was not a great look to the people that he was supervising, because supervisors should have led by example. And the claimant's absence was very serious, and he had taken the number of days that he had taken were just, so his dismissal was just, and it was not in excess of power. Does absenteeism justify immediate dismissal? Absenteeism without leave justifies the immediate dismissal of an employee, and you have to offer ample warnings for misconduct. So this would be important in cases of, if say a employee has been absent from work one time, they show this pattern one time, I would say generally it's not enough. But of course, you have to look at the facts as a whole. Proper documentation on part of the employer, of course, is essential in order for you to bring about a case. And the court will look, like I mentioned earlier, at the employee's job scope and also look at their work record. So going into some more cases, as an example, Vendran against Malaysian airline system. The claimant here was employed for 25 years and he was a clerk. And one day he just got a letter saying that he had been absent from work with no reason for 10 separate occasions, and they asked him to explain himself. So he did reply, and at the domestic inquiry, it was concluded that he was found guilty and was dismissed. So the claimant took the position that, yes, he was absent from work and he knew that he had not obtained prior approval, but he made a claim that he had told his colleagues and for the reasons for his absence. And he also admitted that he did in fact not show up to work those 10 times, but he thought that his punishment was far too harsh considering his 25 years of service with the company. And the company contended that the claimant already had a very poor disciplinary record, and there was evidence showing that not only was his work performance very poor, but there had also been a history of him showing up late to work, not showing up to work at all. And the claimant was given a chance to defend himself, and his explanation was not satisfactory. So the court, of course, dismissed the claimant's claim and held that in considering the claimant's 25 years of service, he did indeed have a history of poor performance, lateness, absenteeism. And in addition to all of that, he had been given multiple warnings for his negligent behavior at work, including an excessive use of medical leave. And because of this, his dismissal was not unfair and not unjust. So in this case, the court stressed that absenteeism, it may appear to be minor, but when done in excess and prolonged periods, employers are not notified of the emergency leave that has not been applied for or unexplained leave afterwards, it will become a very serious problem down the line. So employers are going to be left in the lurch, because if you don't inform anyone, the work that you have been assigned to do for that day, somebody else is going to have to come in and then cover for you. So naturally, this is going to cause a lot of distasteful feelings amongst people in the workplace. Of course, it was dismissed and it was a good reason. One Ahmad Firdaus bin Wan Rosman against Hong Leong Bank Berhad. The claimant here was employed as a personal financial consultant. So here, again, is another case where we are looking at the nature of someone's job. And the claimant here, he had been working perfectly fine. And one day he got a letter saying that he did not meet the required sales targets, and he had been absent from work for 4 days without any sort of reason, which eventually led to his dismissal. So the claimant was saying that the nature of his job allowed him the freedom to not work in the office and not be confined to the office, because most of his time is spent meeting clients outside. And the company was fine with the claimant doing this, because they only prioritized his performance and collections. And the claimant had been doing this kind of working situation for 3 months prior to this event that was not included in the grounds for his dismissal. And the company did have knowledge of this and never took any action, knowing the fact that he did not enter office for 3 months. So the company simply said that the main point to focus on here is that he had been gone from work for 4 days without giving any proper reason. and they did not challenge the contention that the claimant was in fact allowed this sort of working arrangement, working outside of office, meeting clients. And the court had allowed the claimant's claim and held that even though the claimant had been away from the office for 3 months, the company never complained about it despite having full knowledge at the material time. So the company's pattern of behavior has showed that they only cared about the claimant's performance and collections. It didn't matter whether he was in office or not. So they cannot now use that as a reason to fire him when they had condoned this behavior all this time. And we will get into the principle of condonation later on in this talk. So the claimant's dismissal here was without just cause and excuse. And here, principle of condonation. So basically what this is that it relates to an employer's excuse or forgiveness of an employee's wrongful act. It can be done in either an active or passive form, and it operates as a waiver of an employer's right to punish for misconduct. It only applies when the employer has full knowledge of the wrongful act and it must be pleaded. But the word condonation does not have to be used in your plea. It just has to be inferred. So getting into some more cases, we have Public Services Commission of Malaysia against Vigneswari. And here the claimant was employed as a clerk in the postal department. And unfortunately, he had passed before his case had been concluded. So he was replaced by his daughter. The company here commenced disciplinary proceedings against him because they alleged that he had been unlawfully withdrawing money from 16 different accounts in the postal service. So the claimant was denied this, and a police investigation had to be launched. And the claimant contended that this entire time while the police investigation was going on, he was still in the employ of the postal service. And he used this to infer that the company had condoned his behavior, because if he had done something wrong, why continue to hire him and then only fire him 7 years later for something that had occurred 7 years before? So the company's defense of that was that there was not a deliberate delay in sending the show cause letter to him, because there was a delay on part of the police department. They were waiting for the police department to conclude the investigation, and if he was to be found guilty, then they would have terminated him. Otherwise, if he was not found guilty, they would have terminated him without just cause. So here, the company never condoned the acts of the claimant. And the federal court allowed the company's appeal and held that condonation in the context of an employment contract is an act by the employer, either to excuse or forgive one for any sort of wrongful act that has been committed. So condonation can be in an active form, that is by telling someone that they've been forgiven, or by a passive form of not taking any sort of action. So employer in this case had never condoned his actions. They were merely waiting for a decision from the police force. And Zulkifli Ibrahim against Airport Limo. The claimant here was a limousine taxi driver that was absent from work for more than a month, and the company continued to hire of this absence. Company later dismissed this claimant due to his absence from work. And the court here had agreed with the claimant because they held that the company did in fact condone the employee's alleged misconduct and cannot now turn around and use this as a grounds for his dismissal. So the claimant's conduct here, of course, was less than responsible because he should have shown up to work, but the manner in which the company had handled his termination. So this claimant here, he had been absent from work many times. There was a pattern. Suddenly one day, I guess the company decided that they were sick of it and decided to take just the one instance and use it as a reason to terminate him. So this cannot be done. In Nor Bezura binti Dari against Suruhanjaya Perkhidmatan Awal Malaysia, the claimant here was an officer with the diplomatic service. She was frequently absent from work in the year 2014, and then she was made to provide an explanation. She did. They accepted her explanation, so no further disciplinary action was taken against her. And sometime around 2016, further into her employment, again, she continued with these frequent absences at work, and this time the company asked her to explain herself before a disciplinary authority. In front of the disciplinary authority, the claimant had inferred that even though she did not specifically use the word condonation, she said the company had excused her behavior before in 2014. So they never took any action against her in 2014, so clearly to her, they must not have seen it as a big deal. So why would they see it as a big deal now and then choose to terminate her over it? The disciplinary authority had dismissed the claimant, and the claimant appealed to the High Court, and then, of course, that leads us to here today. The High Court had accepted the company's argument that because the claimant did not specifically use the words condonation, that must not have been the case. So the claimant further appealed to the Court of Appeal, and the Court of Appeal had sided with her, saying that even though the term condonation or kemaafan is not found in any of her statutory statements, any of her court papers, the facts from the facts, it can be inferred that they have been pleaded in detail and in plain and simple language to raise this as a grounds for her to apply for judicial review. So in this case, condonation was in fact pleaded. because it could be inferred from the facts. Now, moving on to requirement for annual leave approval, as you all are aware of what annual leave is, and statutorily, there has been set how many days of annual leave is entitled to each employee. You can find this in Section 60E of the Employment Act. And it also goes on to say if an employee is on paid annual leave and in between your period of paid annual leave, you become sick or you are entitled to maternity leave, then your leave will be transferred, as in you will be considered to have taken sick leave or maternity leave in this case, and your annual leave shall be deemed to have not been taken, so you'll still be entitled to it. And if you absent yourself from work frequently, which would mean you often take emergency leave and things like that, it will be deducted from your annual leave entitlement, which is what the first point under 60E means when it says you have shown up to work without a reasonable excuse for 10% of the working days in a full year of service. So if an employer does not comply with annual leave entitlement as prescribed by statute, then an employer is considered to have committed an offence and may and likely will be ordered by the court to pay the employee concerned for the number of leave days that he was entitled to that he did not take. And in addition to that, they may be fined by the court. Unused annual leave, what employers can do, of course, generally employees, you have to finish taking your leave throughout the year. But in the event there is excess, what companies can choose to do is to carry forward the leave. It's up to companies to decide how much you want to allow to be carried forward. Or you can practice encashment, which is to pay your employees for the leave that they did not take. Is annual leave a right or a privilege? Under law, it does not specifically require employees to provide reasons for going on annual leave. The company is also not meant to ask you, but it also doesn't say that annual leave is a freedom that can be exercised solely at the employee's discretion, which means you cannot just decide to go on annual leave simply because you want to. Should you decide that you want to go on annual leave, you have to apply for leave. And if you have some just cause for absence, because no employee can claim as a matter of right a leave of absence without permission, you have to obtain permission from your employer before you go off on your annual leave. So back to the cases, we have Harapan Ramai, Johor against Yaja Desan Rahman. The claimant here was employed as a general worker, but he was dismissed because he had gone on leave on 3 separate occasions, even though he was told that his leave application had not been approved. So he did apply, but he did not specifically obtain an approval. And because of this, the company treated his absence from work as absence without leave, and they issued him 3 separate warning letters. So the claimant, of course, denied having applied for leave at all and went so far as to say that the documents were forged. So the court dismissed the claimant's claim and held that an employee's entitlement to annual leave, it cannot be claimed as a matter of right. You must obtain permission from your employer, who will then allow you to be relieved from your duties of attending work. And unless the leave that you sought is granted, an employee cannot be absent himself from duty. And if he does, it's an absence without leave, and it's a fundamental breach of the employee's contract of employment. So the conduct of the company towards the claimant here had been one of extraordinary patience and forbearance, because they had allowed him to do this multiple times before they decided to fire him. And in furtherance of that, the court also said that the standard of fairness that is demonstrated by the company here far exceeds the reasonable standard that is expected of any other employer before dismissing an employee for an absence without leave. The claimant here contended that the company did not investigate, did not launch a domestic inquiry, and the court took the opinion that this is different because in the case of a dismissal for misconduct and a case where you commit a fundamental breach of a contract of employment, if it's a fundamental breach, then it's just decided that you will be dismissed. It's not a question of whether you had done it or not. So there's no need for an inquiry in case of extreme breach as compared to a case for misconduct. So in the case of Puan Azina binti Aziz against Overseas Assurance Corporation, the claimant here was employed as a receptionist and also served for a very long time, 18 years. And the claimant here did also make a formal application for leave for a set period. But when this period ended, she continued to go on leave and had not told anybody and did not obtain any approval for her further leave. So she was, of course, issued with 2 show cause letters. She replied to it and adduced documents explaining her absence. But the company did not accept her explanations and requested that she report back to work on a specific date, and asked that when she reported back to work, she adduce some more documents to explain her absence. So on that day, she failed to turn up for work again and was subsequently dismissed from the company. And she filed this claim, and the court had dismissed the claimant's claim because the court held that the claimant did not obtain prior approval from the company before going on leave, and she was absent without a leave or permission from the company, making an outright violation of discipline. So the claimant here has also had a very long history of warnings by the company for her repeated conduct, for being absent from work and not obtaining prior approval of the company. So looking at the picture as a whole, due to her poor work history, and for her failing to inform her bosses or her colleagues of the reason for her absence, her dismissal had been justified. In Penang Mutiara Beach Resort against Muhammad Amin Mahmud Halder, the claimant here was an assistant cook who was employed by a hotel and again was directed to report to work on a specific date, which he failed to do. And the claimant claims that he had made an application for leave, but the company completely denies this because if he had made an application for leave according to the policies of the company, then he would have known that the leave form would have had to be signed by the person that was approving the leave. And in this case, the leave form had not been signed. So the claimant knew this and decided to go on leave anyway. So of course, when he filed the claim, the court had dismissed his claim and held that the claimant had committed a grave misconduct by blatantly absenting himself from work without getting prior approval from the hotel. No employee can claim a leave of absence as a matter of right, and remaining absent without leave will in itself constitute a gross violation of discipline. And in Zaihasra Akuma Zainal Abidin against I.TV, claimant here was employed as a business manager of the company. Claimant had applied for her annual leave through the necessary application. So this was an online application that was used, and the online application read that her leave application was pending. And even with knowledge of this, she decided to take her leave. So she did inform her superior that she made the application, made an inquiry as to the status of her leave, which she was then responded that it's not been approved yet, but she still proceeded to go on leave. So when she returned to work, she was of course served with a termination letter and asked to leave the premises. So the claimant's position was that she knew that the leave application that had listed her as pending, but she said that this was because the system itself was not updated, so it wasn't her fault. And the claimant further contended that she wasn't alerted that her leave application had been rejected and made accusations that the company was using this opportunity to capitalize on the fact that the relationship was strained and they just wanted to have her leave the company. So the company, in response to that, in defense of that, they said the claimant's leave was not approved. The claimant did not inform the company that she would not be reporting for work during that period, and it was the sole discretion of the company whether or not to approve their employees' leave. So if the claimant had gone on leave, despite knowing that the leave application system classified her application as pending, then the company's contention was that clearly she is in the wrong. So the court dismissed the claimant's claim and held that the claimant herself was shown to have understood that when the leave application system shows pending, it means that she cannot go on leave because there is no approval. So the claimant made no attempts even to inform her superiors that she was going to take her leave, but she had taken the time to ask the superiors on the status of her leave. So this is clear evidence that she knew about the policy, she knew about the steps that she should have taken. So remaining absent without prior approval from the employer is a gross violation of discipline, which no court will condone. And in furtherance of that, the court also said that it's an employee's obligation to be at the place of work at the times scheduled by the employer. So when an employee is absent from work, the employer's interests will be injured because the employee's work will remain undone and some other employee is going to have to cover the work for her. So while the claimant in this case, she was a first-time offender, but she had a poor working history, not with attendance, but just working history in general. The company decided that as a whole, she was a poor. It just goes to show that the main point is that before you go on annual leave, you have to seek approval from your employer. And with that, I conclude my portion of the talk. So I will hand it over to my co-speaker, John.
Thank you, Jasmine, and thank you, Carolyn, for the introduction earlier. All right, hope you all can view my screen share and can hear me well. I will go on to the next topic, which is an employee's abuse of medical leave, also known as malingering. And I would say that this is a species of absenteeism as well. But when it comes to abuse of medical leave, there is also the elements of dishonesty and breach of trust, which are misconduct on their own. Now, medical leave entitlement, the bare minimum as provided in the Employment Act, we all know it's 14 days, 18 days, and 22 days respectively, based on their years of service, and also 60 days for hospitalization. The Employer must also pay sick leave if there's an examination, if there's an MC by a dental surgeon. So not a dentist merely, but it has to be dental surgery based on section 60F. And it stated that an employee who absents himself on sick leave, which is not certified by a registered medical practitioner, without informing or without attempting to inform his employer of such sick leave within 48 hours, shall be deemed to be absent himself. So that's where the absenteeism element comes in. Absent himself from work without the permission of his employer and without reasonable excuse for the days on which he is so absent from work. So there are few elements here for sick leave. Firstly, it must be certified by a registered medical practitioner. You must inform or attempt to inform your employer of such sick leave within 48 hours, and then you will not be considered to have been absent from work. And of course, there's the criminal provision if you fail to grant sick leave or paid sick leave to your employee under Section 100 of the Employment Act. Now, some examples of abuse of medical leave would include obtaining a fake medical cert, using sick leave or MC for vacation, or just staying at home and not going to work. And repeated sick leave will, of course, result in a termination of employment. Now, it is general principle and quite established that abusing your MC or faking an MC is grounds for immediate dismissal because it is considered serious misconduct. Now, I'll jump straight into some cases. In the case of Jolene Lee, here the claimant, an employee, had signed up for a seminar, and a day before the seminar, the claimant was tasked to complete some work and was directed to not attend the seminar so that the claimant could meet the deadline of completing the work. Now, on the morning of the deadline, which is the same day as the seminar, the claimant fell ill and obtained an MC from the clinic. After obtaining the MC, the claimant headed to her parents' house for rest, but on the way, she made a detour to the location of the seminar to pick up the seminar notes because she felt that she didn't want to waste the fees that was paid. So the company found out, and the following day, the claimant was preparing to go to the clinic again to obtain another MC because she was still unwell. But before she could do so, the company contacted the claimant to inform her that they have prepared and issued a show-cause letter to her because the company thinks that she had lied about being sick so that she could attend the seminar and at the same time failed to complete the work deadline. That was what the company. So this went all the way to the High Court, and the court held that the MC by itself showed that the claimant was not lying about being sick. The company, of course, could not prove the opposite of that. And the court said that just because the claimant was ill does not mean that she must be confined to a bed. It was totally acceptable for her to perform some light activities that do not exert stress. And looking at the facts and circumstances of her conduct, the court found that the seminar venue, the clinic, and the parents' house were all in very close proximity, and she was not going out of her way to drop by when she went to the seminar venue. And especially more importantly, because the burden is on the company's allegation that the claimant had lied about being ill, number one, but was in fact attending the seminar, number two, was not proven here. So the company could not prove that she lied about being ill, and the company also could not prove that she attended the seminar. The only evidence that the company relied on was a signature on the attendance sheet. And the court found that to be not conclusive that she had attended the seminar. The next case is a quite straightforward case, Mbank Berhad against Rasida Othman. Basically here, the claimant came to work and then left to go to a clinic to obtain an MC. And then on that same day, she was spotted at the shopping complex, and I believe this was the Comta shopping complex, after carrying a few shopping bags, and whoever discovered this reported this to the branch manager. So of course, she was dismissed at the end, and the court found that the dismissal was just and fair because a sick worker would have normally just called up the office and informed them the employee would not be turning up for work. The claimant's excuse that she had turned up at the office in order to take her name tag to see the doctor did not hold water as there was no such procedure in place, and that the claimant had neglected to inform any of her colleagues that she had been and was going on medical leave. There was also evidence to show that the claimant had waited for almost 5 hours after visiting the doctor for her husband to pick her up and send her home instead of resorting to public transport, despite allegedly feeling unwell. So the court ultimately held that an employee may be disciplined for malingering and feigning illness to get out of a particular job, that this is misconduct. Next case in Maju Holdings. Here the claimant was firstly issued a warning letter for poor work behavior. So nothing to do with absenteeism or malingering of that sort. However, after receiving the warning letter, the claimant went on a medical leave for a period of 4 days. And at the same time, she had letters to deliver. And so she drove and hand-delivered letters to several branches of the company, spanning across different states. And even after the 4-day MC period, the claimant continued to stay away from work until her dismissal because she was directed to return to work and she did not do so. In court, the claimant admitted that she had driven from Malacca to KL and Shah Alam and back to Malacca to deliver those letters. And she did all that because she said the long drive was to reduce mental agony and was part of the healing process. Now, the court dismissed the claimant's claim and decided that when the MC was issued to the company, it was assumed that the claimant was sick and unfit to work, hence being unable to travel. But the claimant had admitted to traveling more than 350 kilometers despite being on MC and taking multiple sick leaves for these personal engagements. This dismissal was with just cause and excuse. Lastly, this is not so much of an MC case, but it relates to medical issues. Here, the claimant was dismissed for repeatedly taking emergency leave without prior approval and without supporting documents. Here, the claimant took EL 3 times without submitting any application and only stating that his actions was necessary because of COVID-19 pandemic and because he had to care for his young son. So the company issued show-cause letters to him and the claimant did not respond. Instead of responding, the claimant submitted leave applications for 2 of the 3 occasions. But of course, his application was rejected because there were no supporting documents. And the company was very good. The company issued a warning letter and warned him not to repeat it again, but he still did it again and was subsequently dismissed for the misconduct. So the court held that the claimant had failed to justify his absence or support his leave application with adequate documentation. And despite the warnings and opportunities given by the claimant, he still persisted in his misconduct and therefore disrupting the company's operations. And here the court specifically said leave approvals are a must in any working environment, and this is to minimize disruption of the operations. The company was not unwilling to approve leave applications, but the employee must show good grounds for his absence. Yeah, so in that previous case, we can see that even the mere excuse of COVID-19 and taking care of a child may not be sufficient enough to justify your absenteeism or your leave application with the company. And so I will end with some practical tips. So number one, as we've seen in a lot of the cases and in practice and in the industry, you should consider reviewing and improving your employment contract and or handbook so that you detail the working hours, the location of the job, your job scope, leave entitlements, what are the leave application procedures, what is the definition of absenteeism, because most employees may not know that it just takes 2 consecutive days of absenteeism without reasonable excuse to be dismissed. So if you define it, then the employee would be more aware of it and would be more careful. And also the sanctions or punishment that the company may impose when it comes to absenteeism and etc. And of course, all these terms and clauses and rules should be easily accessible for the employees so that you won't face the argument of, oh, we never knew about this. We were never told that this was the working hours. We can't go here. We can't go there. We have to apply this way and all that. So easy access and easy communication would always be the best. Next, we always advise that you improve on your record keeping, whether it's attendance, leaves taken, MCs taken, the absenteeism record, and if any warnings given for these either late leave application or absenteeism and all that. All this record should be kept because we can see from the cases that the court will look at your past history and past conduct. Then when it comes to documents, please ensure a complete and proper filing of all employment documents. This may be letters, emails, notices, memos, WhatsApp messages, everything that you think may be used as evidence to deal with issues of absenteeism or abuse of MC. You need to start keeping them from the very start, not only at the end when these things may have been lost or deleted. Next, you should ensure consistency in your conduct and sanctions. So if you want to be lenient about a certain type of lateness or absenteeism, be consistent across the board. Don't allow for 10 months and then on the 11th month, you are suddenly dismissing your employees. As we've seen in the cases just now, condonation is a strong argument that can be raised by claimants in an unfair dismissal case. So you don't want to end up being in the situation where you have condoned a misconduct for so long. Similarly, in your disciplinary procedures, your show cause letters, your warning letters, or your verbal warnings, be consistent. So, for example, for this level of employees, We will give them 2 chances, and on the third absenteeism or third lateness or third abuse of MC, we will issue warning, or we will give a verbal warning, or we will issue a show cause letter, things like that. Be consistent in these procedures. And lastly, of course, sanctions. When do you give the warnings? When do you give the demotion? When do you give the dismissal? Final slides, when you have meetings and consultations with your employees, take minutes. If possible, record it, video or audio. And of course, at the end, take the attendance and the signature, especially the employee signature, because we have seen many cases where the employees will even deny even attending the meetings. If you have verbal discussions, confirm them in writing. And if you receive any letter or any WhatsApp or email by problematic employees raising queries or raising inaccurate allegations, always reply, respond, or clarify. Do not leave unattended, because it may be used against you in court in the future. Similarly, in your documentation, be consistent. If you have warned an employee about being late on a certain date, and in your final warning letter, final dismissal letter, your ground for dismissing him must be the same. It has to be the same date, and everything should be consistent. Lastly, when you serve any documents like warning letters or show cause letters or dismissal letters on an employee, get their signature and acknowledgement of receipt. And lastly, of course, always seek legal advice as early as possible, so that you can deal with or mitigate your risk as early as possible. So that would be my last slide. Over back to you, Carolyn.
Thank you, John, Jasmine, for your insights. We will now be going into the Q&A session. We have a few questions in the Q&A chat box at the bottom. I will read out the first one. If an employee is earning more than 4,000 ringgit a month, does this absenteeism regulation under the EA still apply to them? Or are they subject to their contract? If the contract is silent, could the employer dismiss the said employee? I will pass this question to Jasmine.
Thank you, Carolyn. So yes, the Employment Act now applies to all employees, except of course the overtime provisions. But the Employment Act says 2 consecutive days, so 2 days in a row. Nevertheless, if your contract says 3 consecutive days, then the company should just follow the contractual terms to be safe, because that is what has been agreed upon between parties. So if the courts decide that the contract term is more favorable than the Employment Act provisions, which is usually the bare minimum in the Employment Act provisions, then the company will be bound by the terms of the contract. So if the contract is silent on this matter, then they will go back and rely on the Employment Act, and the company can dismiss the employee based on the 2 days.
Okay, thank you, Jasmine. The second question we have comes in 2 parts. So a company has informed the employees that it will be closed on February 9th, 2024 and February 13th, 2024 in observance of Chinese New Year. However, the management has also instructed employees to take annual leave on these specified dates, implying a mandatory annual leave. The question is it within the legal rights of an employer to compel the employee to take annual leave during company mandated closure, especially during public holidays such as CNY? And what are the potential liabilities imposed on employers who enforce mandatory annual leave during specified company closure? I will also pass this question over to Jasmine.
Okay, so when it comes to mandated leave or forced leave, as it's sometimes known as, the Employment Act itself is silent on this. And to answer the second part of your question, if this employer's right, if they want to compel an employee to take annual leave during company mandated closure, then it should be expressly stated in the employment contract itself. Then it will be completely fine if parties have agreed to it upon signing the contract, because at the end, the employee himself did agree to the clause. And for the other part, potential liabilities imposed, even if the term is not included in the employment contract, the employer still imposes the mandatory leave, then the liabilities will actually be very minimal. So while the employee can argue that the company cannot force them to go on mandated leave, at the end of the day, the employee is still paid for that leave because it's paid annual leave. So this is not a serious breach of contract, if any at all. So we have not seen any cases on this issue before. Hope that answers your question.
For the third question, we have more of a scenario here. The employee didn't turn out to work for more than a week. The HR has tried to contact him, but he didn't pick up any of the calls. The employee has taken the company's notebook and several files and documents on the assignment assigned to him previously. For this job, it is normal for an employee to bring back documents as they are required to travel outstation. For this case, does the employer need to make a police report, as this involves company assets and confidential and sensitive documents? I will pass this question over to John.
Thank you, Carolyn. Very common issue, very common problem faced by employers. So yes, for this type of cases, we will always advise clients to file a police report as soon as possible. But before you do file that report, you should first commence at least disciplinary procedures like show cause letter or suspension on that employee. Because without starting the procedure, the employee technically is still an employee. And so it would not be wrong for him or her to be keeping the assets. So only when you start that procedure, then you can tell the police, okay, he's been absent for so long, we've started this procedure, and he's keeping some assets and documents which are confidential, and we are making this report now. Thank you.
Thank you, John. And next question is, for an employee under probation, can the employer not allow employees to take leave during their probation period? I will pass this one to John as well.
Yeah, thanks, Carolyn. Okay, so the Employment Act just mentions employee when we talk about leave, and a probationer is technically an employee. It is our opinion that an employer cannot or should not deny a probationer's leave application during the probation period. But so, however, what the employer can do is to maybe prorate the leave entitlement during that probation period. And so maybe during that 6 months, the employee, that probationer maybe would be allowed 1 or 2 days or 1.5 days or something like that, depending on his full entitlement for that year. But again, most importantly, this should all be stated in the employment contract so that the company mitigates its risk a little bit there.
Thank you, John and Jasmine. In the interest of time, because I think we have to end soon, the rest of the questions, if you would like to reach out to our firm, you can always contact us through our website or drop us a call. But before we conclude, I do have a few announcements to make. First, please join us again for our upcoming talks. The next one will be on the 10th of January on stamp duty rates and exemptions, and it will be given by our own Vincent Cheng. You can also scan the QR code on the screen to sign up for this talk. Please also do join us for our upcoming Academy talk titled Corporate Social Responsibility, Business and Human Rights, which will be held on the 19th of January 2024 from 2 p.m. to 6 p.m. at Work TTDI Glo Damansara Mall with our consultant, Dato' Mawing Wai. He will be the speaker for this seminar. This workshop will cover all the essential elements of leading companies to seamlessly integrate ethical practices, translating them into heightened revenues, enhanced brand loyalty, and increased market positioning. Don't miss out on the opportunity to gain valuable insights and secure the early bird prize by scanning the QR code on the screen or by clicking the link provided in the chat box. We'll also fill in our feedback form and tell us what you thought of this talk. The link to the form will also be posted in the chat. If you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box, or you can scan the QR code on the screen as well. To all of our guests, thank you so much for joining us. We hope that you have found today's session informative and useful. Thank you, everybody, and we will see you at the next talk.